scheduled for a promotion hearing this morning. So I'm curious to know of which cases is the state ready to go forward with first of all.
Your Honor, I believe that with regard to Ms. Elizabeth Randall. In that case, that was position number 13 on your calendar on Tuesday. You set it to today for a Jacksonville hearing. The state will be ready as soon as Officer Roth arrives. He's on his way. So he's walking over from APD. And then I also do have Officers Castro and Officer Spence on Zoom, as you did allow the state to do.
We may have to check your mic at the table. Officer Castro and Officer Kevin. I just have your first name, Officer Kevin. What's your last name? Is it Kyle?
Spence.
Spence. Okay, I can read the Zoom. Okay. The host may want to amend that to Officer Kevin Spence. All right, we are still waiting on one more officer for the case at State v. Randall. And Ms. Howard is our court reporter for this. Okay. Everybody else on the Zoom is either the camera from in the courtroom G33 at 165 Street, or we have the court staff, Ms. Younger and Ms. Chatterton. So, and of course our host with the Zoom proceeding. No, we have a challenge. We do have Ms. Bolton in the courtroom. All right. So we're going to hold off on.
We got some preliminaries we need to do before you want me to go ahead. I don't think we need the officer for that.
All right. Officer
That-
Castro and Officer Spence, we're going to address you as soon as Officer Roth appears in the courtroom, and then we will commence. Okay. So this is State v. Elizabeth Randall, 20 CR 003-075Y. Ms. Randall is present in the courtroom, and she's seated at the defense table with her attorney, Mr. Michael Rocco. Representing the state will be Ms. Angela Walgrove. And Mr. Rocco, you have the mic in front of you. What's the first matter you'd like to?
John, I'm assisted today by attorney Rose Woodbury. First is we do withdraw the motion to suppress that was filed. I mentioned that the other day. Second, I want to make a motion and eliminate short. We want asking the court to instruct the state and its witnesses from commenting on any refusal that she may have made to take any chemical or other blood alcohol test, blood tests, or including the breathalyzer if trial.
So you're asking the state to not comment on the defendant's refusal to take any kind of test that is requested by the officer from the implied consent notice, as well as the alpha sensor.
Right.
And the grounds for this refusal, for this motion?
There's case law that's that yes, Olivet versus State 302 Georgia 228 2017, and the Elliott case, which is the recent case 305 Georgia 179 219.
We can stipulate the PBT.
Yes. Ms. Waldrop or Ms. Reisen? Yeah.
Yes, Your Honor. Okay, so with respect to the refusal to submit to the PBT, the state does stipulate, we understand that that is out via Ammons. With regard to the request for implied consent that was read by Officer Roth specifically requested a blood test. And as you know, Your Honor, that is in. Elliott does exclude the refusal to take a breath test. However, it does not apply to blood, and the refusal to take a blood test, which is what was specifically requested by Officer Roth, can be used against the defendant at trial.
Rebuttal?
I'm sticking by my motion.
Okay.
I'm staying with my motion.
If there is any request for a breathalyzer test, that motion would have been granted, with regards to any other test of any other bodily fluids or any other samples. The Elliott has not made any reservation to that topic, so the motion is denied. Anything else, Mr.
Yes,
Russell?
several things. As to the Jackson Deno, here's what we're gonna do. We're gonna consent to any actual statements coming in that the defendant made at the scene in any of those videos, but we don't consent to any other statements that are not on the video, off the record, at Grady, or somewhere else. If they're on the video and are statements of the defendant, we're not gonna object.
Not made, statements not made at, off the video. And maybe not at the scene. Anything else?
As to that issue, no.
Right, statements, defendant statements which were made off the video, made at Grady, not at the DUI scene. I only have 3, but would you have made it anywhere else? In the vehicle, being transported?
No, as long as, oh, yes, and in the vehicle being transported, correct, I'm sorry. Thank you.
So I've got any statements made by defendant that were off any body cam or video footage by the officers or by the state, made at Grady Hospital, made in the police vehicle, and otherwise not made at the scene of where she was stopped in her vehicle. The defense would like such statements to be suppressed.
Fight directly.
Ms. Howell, our court is not on the Zoom.
Sorry, I interrupt you on this.
I'm here. I had to move to another device. I wasn't able to speak where you could hear me.
Okay.
I'm having a lot of difficulty hearing from the defense side, so I'm trying. I've got another device running, but I am here.
Okay,
Moving it to another room. I think it might be my Wi-Fi. I apologize.
okay. The only thing I can recommend is, Ms. Roseberry, if you could move the microphone closer to Mr. Roffa. Yeah, okay, good. And Ms. Waldrop, that microphone needs to be closer to you as well. All right. Could you do a test, testing, 1, 2, 3?
Testing, 1, 2, 3.
Ms. Howard, could you hear Ms. Waldrop? Court reporter Courtney Howard, could you unmute, please?
Sorry, I had to get the charger.
Ms. Howard, I just want to verify that you can hear the prosecutor. She's going to do a test again. Go ahead.
Testing, 1, 2, 3.
Yes.
All right. Sometimes if you switch off your video and just leave your audio on, that would assist with the bandwidth.
Okay, thank you. I apologize for interrupting.
No problem. I want to also test that you can hear the defense counsel, Mr. Roffa. Mr. Roffa, testing.
Testing, 1, 2, 3.
Ms. Howard, can you hear Mr. Roffa? You need to unmute.
She's muted.
We can't hear you on that device. You need to move to the other device. Or if you can hear Mr. Roffa, give me a thumbs up. All right, perfect. All right, so getting back to the second motion in limine, they are willing to limit any statements being admitted if the state agrees that certain statements made not on video footage should be excluded.
Your Honor, I just want to be specific that, because the state is agreeable to statements that are not on the video.
Not on any state video, right? Not officer's video or body cam or,
Correct, but the statements on the officer's video, the state wants in,
okay?
obviously. But anything off video,
Anything off video? What about statements made at Grady?
so I don't believe that anything that was made at Grady will be using.
Okay, what about in the police officer's vehicle?
Yeah, we don't have an objection to that, Judge.
And anything else off video but made at the DUI scene?
There aren't any statements that are off video that were made at the DUI scene. The statements made at the DUI scene, I have on the body cam of Officers Castro and Ross.
So based on the representation from Ms. Waldrop, do we consider the Jackson Deno hearing resolved?
That would resolve it.
Right? So any comments made by Ms. Randall that are documented on any video footage by police officers or anything on video shall be admitted. Anything else are not. Anything else to address in this case, Mr. Randall?
Yes, we filed a demur to the open container statute, and Ms. Roseberry is ready to argue that motion. It's a short presentation.
All right.
Yes, Your Honor.
You may be seated and have the microphone near you.
Oh, okay.
Audio, thank you.
Yes, Judge. Judge, the accusation with which Ms. Randall is charged in the open container, with open container violation, states that she did unlawfully possess an open container of an alcoholic beverage, to wit, alcohol which was immediately capable of being consumed, and from which the seal had been broken while operating a vehicle in violation of OCGA 46-253. OCGA 40-6-253 requires that the beverage be found in the passenger area of any motor vehicle which is on the roadway or shoulder of any public highway. That language about being on the roadway or shoulder of any public highway is missing from the accusation. We are past, and it's an essential element of the crime. There's a case that's directly on point to this issue. It's Sexton Johnson v. State, 354 Georgia Ave 646, 2020. Judge, there's a fatal defect in the indictment. We are past the statute of limitations because this incident was alleged to have occurred on May 11th, 2019. The 2 years plus the tolling time for COVID would put us, by my calculation, I used an online date calculator, allowing 2 years for the statute of limitations and 474 days for the COVID tolling would put us at August 28th, 2022.
August 28, 2022.
Right.
What?
That would have been the deadline that the state had to amend the accusation and fix the mistake. So at this point, they cannot amend the accusation. And if they were to amend it, my argument is that it would be a void accusation. It's already a void accusation. I'm also citing to Pennington v. State, which is 323 Georgia Ave 98, 2013, which states that substantially amending the original charges is adding elements that are separate and distinct from the crimes charged in the original charges. So Judge, we're asking that the open container violation be dismissed.
All right. Ms. Waldrop?
Your Honor, with regard to that count of possession of open alcohol container, the state does stipulate to that particular count being out, will not go forward on that count. I do want to make it clear that the open containers that were found in the vehicle and observed by the officers in the vehicle, that is very much relevant, that evidence is relevant to the DUI. And so with the understanding that the evidence of the open containers, we can present at trial, we're not going forward on the possession of open alcohol container count.
All right. Ms. Rosemary? Roseberry.
Rose Woodbury.
Rose Woodbury, sorry. Yes, and any response to that?
No, Your Honor.
All right, the motion to dismiss the one count of open alcohol container under 40-6-253 is granted. Of course, with the caveat that any evidence with regards to the presence of any alleged open containers of alcoholic beverages found within the vehicle in question shall be admitted subject to any
Subject to
corrections.
any objection I can make up between now and Friday.
That's yeah, you got it. Thank you. All right, anything else from the defense?
Yes, sir, we have the eval motion.
Okay,
First of all, I don't waive any privileges as to the facts stated. This is the way we used to do these eval motions. Now they're supposed to do them ex parte. I didn't exactly do that. So I would ask that all of the parties clear the courtroom except the prosecutors. They've already heard this anyway. But I don't wish to waive the results of any eval. As I understand the law, that eval report would go to the court and to the defense attorney. And it's one, up to us whether to release it, or two, it's up to the court upon motion. There might be a reason to release it.
okay,
So I would ask the court when you declare it except for this.
all right.
It's-
Counts, just one thing. Do you have any objection to going into a breakout to hear the mental health evaluation request?
No, Your Honor, but if we're done with the Jackson Dino portion of the hearing, I can go ahead and excuse my officers. I just need a few minutes to speak with them.
Are we going to be calling a jury trial today?
Your Honor, it's my understanding that if there's a pending motion for an evaluation, we can't go forward today with the jury trial. I mean, that's.
And if I deny it?
I'm sorry,
If I deny it?
Your Honor, then, I guess then the state would go forward, but I think that's reversible error for us to move forward if there's a,
I don't know what's the basis of the motion yet. I have no idea.
then we can go ahead and excuse the officer and I can call them back in.
Okay. Officer Spence, Officer Castro, you're going to be excused at the present time. If we do go to trial, it may be tomorrow. So please note that you are on call, okay, until you hear otherwise. Thank you very much for being here. You're free to go. Officer Roth is going to be here for the MH motion, yes?
I don't believe he's necessary, but he can step outside and then he can come back in if we.
Yeah, we did ask that he step outside.
All right. Officer Roth, if you don't mind. And counsel, you are here for the other motion?
Yeah, Travis, right?
Travis White. Okay.
Your Honor, that'll be a plea this morning.
Okay. The rest, Mr. Wright, is it a plea in absentia?
No, he's on his way to the chief.
Okay.
I was just curious.
If you'd be kind enough to step outside, we'll call you in when required. Officer Castro, did you have a question, sir? Are you on mute, sir?
Yeah, Your Honor, can you hear me?
Yes.
Okay, I just want to make sure you guys can hear me. That's all. No, I understood everything. Thank you so much.
Thank you so much. Pretty good. Thank you.
Thank you. Bye-bye. Thank you.
Bye. Okay, so on Zoom presently, we're going to